good morning and a warm welcome all of you. I am Dr. Sairam, Director of Goa Institute of Public Administration and Rural Development. I am welcoming you all for this today's lecture, an important lecture related to digital data protection. Data capturing is happening of every citizen of the country in one pretext or the other. Therefore, the context of privacy of data, protection of personal data has become paramount importance over the period. In that context, this legislation brought out by the Government of India has significance to every citizen of the country. Therefore, though this lecture is organized mainly to the young Goa civil service officers who are entering the state administration, we thought it important in public interest. Sairam Bhat, a professor of law at National School of India, University, Bangalore. He is also Center Coordinator for Center for Environmental Law Education, Research and Advocacy. He has co-authored a book on Environmental Law Handbook for Law Practitioners in the year 2022. He is a recipient of Young India Environmental Law Fellowship in the year 2023. He is also a recipient of Fulbright Fellowship in the year 2010. He was adjunct faculty at Golden Gate University, San Francisco in the year 2003. He is the editor of Law Relating to Business Contracts in India, published by Sage India in 2009. He has authored Natural Resources Conservation Law, published by Sage India in the year 2010. A visiting researcher at Georgetown University Law Center, Linus Palm Academic Exchange Fellow at Royal Institute of Technology, Stockholm, Sweden. It gives me immense pleasure to welcome on behalf of Government of Goa and also in particular on behalf of this institute, Dr. Bhat, to deliver this lecture for the benefit of everyone. And I leave this floor to Dr. Bhat, and I request you to take benefit of this lecture. I am sure we are first among few in the country to ignite a debate on this particular important piece of legislation. Thank you very much.
Good morning to everyone. I'm joined by my colleague Rohit Kamath, who is an advocate and who works with us. Thank you for this opportunity, Dr. Seema, Dr. Sairam Bhat, the faculty at Gippard. I'm coming here after some time, but it's always good to come. The topic is privacy law, and we are looking at a new law that is passed by the Parliament of India called the Digital Personal Protection Act. And this is a very interesting piece of legislation. It has taken more than 4 years and 3 bills for this law to come into existence. So I'll try and look at why this law came into place. I think that is the way you can at least understand what this law contains. Okay. So I think, the first thing, I don't like doing a lecture mode, but I'll try because this is online. Privacy in India is a very interesting concept. We don't care actually for it. You must be wondering, sir, what a provocative statement. But it's true. We don't care for privacy. We are all social, rational animals, so we like to interact, we like to share. Rather, India was a country that did not look at intellectual property very seriously. The West imposed intellectual property. They said knowledge is, economic power. So we'll exploit that knowledge. India, if you have knowledge, someone like me comes here and shares a lecture, we don't create copyright out of PPTs and other things. So India is a different society. But interestingly, when European Union passed a very interesting, mandate called GDPR, General Data Protection Regulation. Then in India, this whole debate upon privacy came into existence. Otherwise, we had not much value to privacy. But the problem actually came because of several things. Friends, please note, till 1990s, most of what would be done in India was basically government done. Okay. The government was collecting most of our data. There is no problem because we trusted the government, and government is of the people, by the people and for the people. But after 1991, we came into a stage of liberalization, privatization and globalization. And you will notice that from being a socialistic kind of a country, we slowly looked at privatization. So government started deregulating many of the sectors. They said, let private investment come in, let private players also come in. We opened our markets. Liberalization means that. So Coca-Cola that was sent away from India in the 1970s was called back in the 1990s. He said Coca-Cola chahiye. The local drinks were not much of our favor. Torino and Gold Spot. He said, no, we want an international, multinational drink. So a lot of US companies started coming into India. Please note, the Indian consumer market is a huge market. Right? Our service industry started flourishing, especially IT. We started making a lot of business. We started getting opportunities to go to the US. So the country started opening what we call as their borders. Right? Once you open up your borders, you are opening up so many other challenges as well. Actually, to be honest, in the 1990s, lawyers did not have much demand because we were only filing civil cases and family cases and criminal cases. Today, lawyers have a great demand because we can look at international cases. And interestingly, thanks to this data privacy law, lawyers have a new job. The job is called a data privacy officer. So only lawyers can qualify, interestingly. So I'm happy for my community, that's a different issue. But the point is, when some of the companies like Google, Facebook came to India, they started probably collecting what we call as sovereign citizens data. Of course, all of us have a Gmail account. Before Gmail, I think we had Yahoo, we had so many other accounts, but Gmail gave us a free account. Now free means Indians like, we like everything that is free and we think that's the best thing to do. But there was already a trap there. Right? What was the trap? The trap was these companies, much before you thought about what AI was, these companies would actually track what you sent in your email. Right? Now, why did Google give you a free Gmail account? What was their benefit? It was not a paid account, is it? Most of us, how many of you have a paid account of Gmail? Only Rohit has. That is because, he's a lawyer, he has to have a paid account and so on and so forth. We all like free accounts, isn't it? But why did Google do this so-called charitable service? See, please note, what I'm saying in this lecture is not to defame any entity, association or company, and no animal is going to be hurt in my example. So disclaimer is to be there in every of these talks. But please note, you will notice that immediately Google will send you advertisements. Do you see some relevant advertisement on the right side of your Gmail? And you will be surprised, right? How did Google know that I am interested in apparels? I am interested in having a fish curry today. Oh my God. Where is Google getting all these ideas? Right? So this was what was the, USP, if you want to call it. That they would do data mining. And through advertisement, they would cover their cost. Rather, advertisement pays them more than what your subscription pays them. Even Facebook for that matter, how does Facebook or how did Facebook, while giving you a free account to publish your photographs, to publish your social media post or anything else, how did Facebook make money? How is it a $1 billion kind of an industry worldwide? Because Facebook and Google made more money than you and me through advertisements. Right? So the advertisers started using some of these social medias. And interestingly, many of the Indian companies started putting their advertisement on Facebook and Google. Right? But that's the process in which, what we used to put or what we continue to put on Insta or WhatsApp or any other is going to be tracked by these companies. Right? Now, interestingly, the question is that, fine, what's the big problem? The problem is you must be saying, sir, it's by my own choice and by consent that I am over there. Right? So let's assume that you want your photograph to be published in a newspaper. Okay? You want your advertisement to be published in a newspaper. No problem. You can publish. There is no problem. Now you know that this newspaper will actually kind of go off, the ink may go off in a couple of years. You know that this newspaper is not going to be stored anywhere in someone's house. It may be used by one Belpuri wala. It may go to a kabaddi wala. Okay? Or the newspaper may be burnt. So you know at some point of time what you have published over there as an advertisement in the paper will be destroyed. It will vanish. No problem. Even if my photo comes, I know someday it will go off. But the problem with the digital information is it never goes off. Right? It stays somewhere. Either it will stay in one database or some other database or in some server or in the dark web. Somewhere it will be always there. Right? You will never be able to track where this information is going to be. And interestingly, you will never know who is doing what with your photographs or information. That is the danger of internet. That is the problem of internet. Right? And that's why European Union, which has passed some very fantastic legislations, came up with their GDPR guidelines. And interestingly, what they said in their GDPR guidelines is very important, friends. They said that European citizens' information is of topmost priority. Right? And we will regulate all these social media companies or these companies that are having digital information. We will control them. We will hold them. And then we will decide how to, treat this information. Because they said information of European citizens must be protected in Europe. This is called data sovereignty. Actually, the most important nation that has done what is known as data sovereignty is China. Chinese citizens' nationals' data is in China. Did you know this? Where are Indian citizens' data? You may say Google India, Facebook India. They are India only for India. But where is your data finally getting stored? Because please note, friends, there are a lot of nations which are doing so-called what we call as ethical hacking. I don't know what is ethical in hacking, but nevertheless they say that. Somewhere some nation is going to actually start collecting these data. Right? That could be what we call as a cyber breach or security breach of that kind of a data. There may be a Russian or a Chinese who is trying to, and please note already a lot of presidents of different countries are worried about all these cyber attacks that can actually happen. So to be honest, in this law for the last 4 years, one of the most contentious issues was, can we continue to keep Indian citizens' data in India? Can you keep your photographs in India? Can you put your passwords in India? Can you put all your social media accounts or Twitter messages in India? Now you will be saying, sir, why should it be in India? What's the problem? Let it be anywhere. It's one earth, one world, one family. Not a problem. But the problem, friends, is the regulatory territorial jurisdiction. Tomorrow, if this data is to be protected or if this data has to be secured, if these companies or these servers are not in your territorial jurisdiction, you cannot regulate it. You can't control the flow of this data. These companies will not adhere to your court regulations or your executive directions. They may say, sir, we want to do it, but the data is somewhere else in Ireland or some other country. So please note, friends, data sovereignty. This word sovereign means, I hope you understand and appreciate it. We use this in the preamble of the Constitution as well, where we say we should have the supreme power to decide. It's not a colonial power to decide. It's not someone else who will decide. But Google and Facebook will actually decide as per US law. And that's why there is a problem in India to regulate some of these social media companies, because please note, in one of those interesting parliamentary committees, Facebook said, look, we are bound by only the American Constitution. We are not bound by the Indian Constitution. We like free speech, absolute free speech. Your free speech has too many restrictions under Article 19(2) of the Constitution. Then, you had to do arm twisting and you have to say, look, we'll have to probably block your account. Then Facebook said, okay, please note, they constituted a committee of 20 Indian experts, which will now decide what kind of content should go to Facebook. You know why? Because Facebook has the potential to do what you may want to not like or call it, called election interference. Social media is very powerful. They can, as I told you, what is data mining? Suppose there is election in Goa. I will start saying, this is the party that has not performed well. Immediately you will notice those posts that are in tune with your thoughts will immediately start coming and showing you over there. Right? You will know who are my supporters and who are not my supporters. And please note, those people who went from India and joined ISIS, right? They were all actually encouraged by Facebook posts. Shamina Begum from London, when she joined, went to Syria, 3 girls walked out of the Heathrow airport. They were all influenced by Facebook posts. Very young girls, school-going kids. Facebook has that, kind of influence on our young minds. So you will probably say, oh, this is where some of these companies are trying to control the narrative of elections as well. Right? Because naturally what you will do, it may provoke you against one particular government. It may instigate you against one particular political party. And this can be actually staged, it can be actually managed. The algorithms can be so designed that what you see on your LinkedIn, on your Facebook, on your Insta can easily be controlled and monitored. Right? You just start seeing 2 or 3, on Insta, just spend a couple of more time on one particular topic. Only those kinds of reels and short videos are going to come to you. They are so well structured. So there are those challenges that come, right? And hence, I think what is data and what is privacy became a huge concern, right? And that is what was the complete idea of whether India should get a Digital Personal Protection Act. Now please note, it is digital and personal. It's not non-digital and non-personal. I'll tell you what is the distinction slightly later. But that also becomes critical and important. Interestingly, friends, I am just going to try and look at the Right to Information Act as well. Because in 2005, when RTI came into place, under section 81J, there was an exemption. And that exemption is that you will not be given information that is personal information. So under 81J, there is an exemption that personal information will not be shared under RTI. So let me try and correlate these two so that you get some kind of an idea of where we stand. Okay. Now, going a little further, friends, if you look at the history and origin of privacy, privacy can be broadly divided into 3 categories. One, we say, do companies have privacy? Does government have privacy? Friends, there is a distinction between data that is private and data that is not private, because we are talking of all categories of information. Friends, privacy is generally bodily privacy. This is traditional form of privacy, bodily. Second, can you claim privacy of a property? This is all in law. How do we categorize? Can your property be your privacy? You must be saying, sir, give me at least 1 or 2 examples of it. Let me give you one very interesting example. Friends, assume that you are my neighbor and I already have a house that is built. You start building your house next to me and you plan your window just right opposite my bedroom window. Can you do that? You just say yes or no from the right answer. Why not? No, just to answer yes or no is the most easiest answer. To tell why and to quote the law under which you cannot do it is the most difficult part, isn't it? Do you have privacy of your property? For example, you must be saying, this laptop, is this my property? Of course it is. Can I have privacy of this property? Right. Does property also come within the domain of privacy? The answer is an absolute yes. And that's why, friends, please note, when the police or the government enters any private property, it has to have a warrant. It has to have a search warrant, because that is my privacy. You may have the power of law, but unless you have the authority of law, you can't enter my premises, because my premises is a private premises. So property also is within the domain of privacy. Interestingly, we have a law, which is a British law, called the Indian Easement Act, under which for the first time you had privacy of property. Land was considered as property, movable property, immovable property. Let me just give you one more instance or example, because I think you will understand privacy with examples. You know, at one point of time, we Indians liked privacy a lot. I don't know why, what happened and how it changed, but you know, it was there. And that's why whenever we had a car, we had tinted glasses. We used to like tint. You know, I don't know why. Maybe to protect from sun or to protect privacy. It could be either, right? Now, unfortunately, what happened is this was considered as tampering of a motor vehicle under the Motor Vehicles Act of 1988. And post certain sexual assault cases in a moving car, the Supreme Court had to step in and say, sorry, remove this tint. So, a lot of time, you know, what is right to privacy, if you ask me, friends? It is called the right to be left alone. Rather, privacy is a negative right. Did you even know this? It's a negative right. So rights are divided into two categories. Private, we say positive rights and negative rights. A positive right is a right in which you assert something. Say right to water is a positive right. He's just drinking that. Yeah? You want water to quench your thirst and its life. You can demand it from the state, right to water. But in right to privacy, you demand from the state to be left alone. Don't disturb me, leave me alone. Right? So usually privacy is considered as a negative right, traditionally, right? Your property, your bodily privacy. For example, you know, in the United States, they came up with a full body scanner for the first time, a couple of years back. I just entered US. Then I was asked to stand in the scanner, something like this. I was like, okay. Then I was told that it scans your entire body. It's not like the metal scanner that our officers use, but it's a full body scanner. So it will know everything about it. Right? So interestingly, the LGBTQ community, especially the transgenders, took an objection to it. They said, look, this may disclose my gender if you go in for a full body scanner and it violates my right to privacy. But unfortunately, 9/11 had just happened in the US, and the government justified saying security is more important than privacy. So bodily privacy is of course there. You definitely have that right. But as we say, no right is an absolute right. Every right is to be sacrificed at some point of time for the interest of the nation. And that's why in 1923, friends, when it came to government, we said that government has the right to keep things secret, right? To keep things private. And this will not be disclosed at all. So you can actually classify things as secret, top secret, and confidential. Once that is done, it will not come into the public domain. You can hold on to it. You can treat it as confidential information. So when it comes to legal persons, when it comes to companies, when it comes to government, please note the information that we say is to be kept is called confidential information. Right? That's why we say personal information is different from information of entities. Let me give you another instance. For example, taking Dr. Seema's example. Dr. Seema may say, I have a lot of personal information. She can claim it. But if she is working for an organization, the organization cannot claim personal information. The organization can claim confidential information. So we started categorizing this. How to categorize, how to deal with this. Right? For example, Dr. Seema is covered under a law. Please note, before we got this Digital Personal Act, Privacy Act, Dr. Seema's personal information was covered under a law called the Information Technology Act of 2000. We had rules, if some of you are interested in law and rules, called the SPDI rules, Sensitive Personal Data Protection Rules. And Dr. Seema's name, her phone number, her email ID, her biometric, if it was collected in this organization, can all be protected under the Information Technology Act. At the same time, GIPAR's information about participants, who is the resource person, where is he coming from, his travel bills, his medical bills, etc. etc. Please note, though it may relate to some individual, it is all some information about the institution. So institutional information was called as confidential information. If you want to refer to section 72 of the Information Technology Act, please note it down. Rather, the IT rules actually created a criminal punishment for breach of confidential institutional information. Naturally, we have a lot of cases, right? Some disgruntled employee trying to delete certain files in a system or a computer, an employee trying to transfer, proprietary and personal information to someone else without authority. Those are actually criminal actions. Did you know this? And even a government or a private employee could actually be prosecuted under that section for breach of confidentiality. The Information Technology Act had those kind of sections. So of course, trying to understand official secrets and personal secrets becomes an relevant factor. Right? Okay, just as a matter of secrets, how many of us like to have some secrets in our life? We all have some secrets? No, not the controversial ones. We can keep them aside. Do you have some secrets? We all like to be very transparent, let RTA apply in full. We can't say that. All of us may have some secrets, right? I'm sure there's a small thief somewhere in our heart and mind and soul. And that thief could be as small as, trying to copy when we were in school or college. There's someone knows the answer. Maybe we have some secrets. Now, interestingly, friends, some of these secrets are critical at times. It need not be disclosed. Lord Krishna himself had said, tell the truth that people should know, but don't tell the truth that people need not know. Okay, my name is Bhat Sairam Gopal Krishna, so there is a small Krishna in my name as well. But that's why I'm telling you all that. So the point is, friends, government also needs to keep certain secrets. We also should have the right to keep those secrets. And please note, friends, privacy is nothing but those secrets. Yes. Let me tell you, in GDPR, okay, how many of you have given your phone numbers whenever you've gone to a shopping mall? I think your phone number is everywhere, right? If I go to Truecaller, I'll get your phone number. If I go to Shopper Stop also, I'll get your phone number. If I go to some hotel also, before you log in, it's a phone number. Friends, in Europe, phone number is actually your personal secret information. You need not disclose this. Yeah, you need not. So a lot of Europeans, when they come to India, they're a little shocked. They actually tell me, our phone number is asked. Why is nothing in India happening without a phone number? I said, sir, that's linked to Aadhaar, it's linked to your bank account. We have a unique ID. I said, oh really? What's your unique ID? Because in US there is something called social security number. You have a different ID. You can have a social security card, give it in the US. Europe also, in some of the countries, there is a separate ID number. Okay. So I said, we also have some unique ID number. And they said, what is it? I said, your phone number is your unique ID number. Even if you don't remember your name, you should remember your phone number. That runs in India. But interestingly, friends, your email ID is your personal information. Please note, SBDI rule says your email ID is your personal information. But your phone number is no longer your personal information. Isn't that strange dichotomy that exists? So what can you keep as secrets? Can anyone give me one or two examples? What would you want to keep it as personal information, as private, under the rule of privacy? Give me one or two examples. Your name is not personal any longer because you're already in government. Your address is personal information. That also, I'm sure, if you're an IAS officer or anything, you go to DOPT website, I don't know which is the website for Goa, I can get your address as well. It's not difficult. Google has penetrated too much and too deep. And if you actually look at it, if you give me your address, I can know where your house is also. And I can tell you which color you have painted your house also. Google Earth will give you most of this information. Anyway, and yeah, of course, 2 floors, 1 floor, and suppose you come on the top of the floor, then I can even read that. I'm not sure. I'm just saying. Yeah, your address seems to be, okay, let's assume it is. What else do you think is going to be your personal information? Bank details. Okay, fair enough. Sure. Your signature is your personal. Okay. Which one? Digital signature or physical signature? Both. Very good. Okay. But yeah, you're right. Any other?
So family relations.
Oh my God. Okay, that's too personal. Okay, but you said family. That's too broad. Yeah. Okay. What else? So you think this law is only for your address, your family, your bank details? It's only for that? Mobile. Okay. No, friends, I think there are a lot of personal information. There is a lot of personal information. And I'll just come to that with a lot of examples because those are ones that you should know whether they're protected under the law or not. Okay. Now, historically, if you look at what privacy came in, the Supreme Court of India has decided privacy in several contexts. So let me put those contexts so that you appreciate the law on privacy in India. Friends, how many of you, you just joined service, would like to write a book, either during service or post-service? Dr. Sairam and me probably can think of writing a book.
I've already decided.
You have, okay. Can we write a book talking about your experience in your organization, in your department, in your government? How was it? Whether you had good colleagues or not? Which colleague was good and which was bad? Because now you are retired, pensionable job. What's the problem? Friends, interestingly, there was a very important case on what we call as General V.K. Singh. Okay. This is not the army general. He was another V.K. Singh. General V.K. Singh worked in RAW for nearly 32 years. And later on, RAW has a problem. And that point of time, they had a problem. They said there are a lot of these RAW agents that were actually going as double agents, going off the radar. So they were losing a lot of agents. And V.K. Singh was kind of concerned. He had a strategy in place. Of course, when you go to your boss just before retirement, which boss will listen to you? So he kept on going to the boss and saying, sir, please implement my strategy. He said, आदमी बुड्ढा हो गया, इसका क्या सुनेंगे? तो हमारा जो है वही सुनेंगे. So he said, okay, I'll wait till retirement. Then after he retired, he decided to write a book on RAW. See, you can write your autobiography. That's okay. Right? Abdul Kalam ji also wrote his autobiography, so it's fine. But he wanted to write about RAW, and the government of India came to know about this. And they seized the publication material because they said this is a violation of the Official Secrets Act. Friends, interestingly, as government employees, you are bound to your personal secrets. But are you also duty bound to hold government secrets? The answer is yes, you are. That's an obligation that is imposed under this law called the Official Secrets Act. And please note, you're not duty bound only to keep this information secret during your service, but even post that service. Right? You may say writing a book is a freedom of speech and expression. I am writing my own personal details in that. What so? you can definitely claim that. But if it is directly or indirectly impacting government secrets, because government also can hold on to its own confidentiality, and the law will protect that as well. So there are several such cases, friends, where people have attempted to write books. For example, in this Raj Gopal case, in this case, this guy was a convict, he was in jail. But when he was a notorious criminal, he had a lot of connections with politicians and police officers. So now he thought that in jail he'll write a book exposing these politicians and police officers. So he decided to write the manuscript. Naturally, the jailers keep seeing what you write and what you don't write. So the jailer informed the politicians and police officers, "Aapka naam going to be disclosed." So they went to the court. They said, "Arro, no, please, our privacy will be breached if he writes this book." So, your privacy may be breached by government. It can be breached by even a publisher. For example, the most famous case, I have it over here, is on Khushwant Singh. Khushwant Singh decided to write a book. It was popularly going to be titled as Love and Libel. Libel means defamation. Okay, libel, slander and libel are two forms of defamation. And in this book, please note, he was in a close friendship with the Gandhi families at one point of time. And he was much more closer to Sanjay and Menaka Gandhi. But of course, later on, differences arose. And after the differences arose, Khushwant Singh, a very famous author, please note, decided to write a book on Menaka Gandhi and how she fell apart with Mrs. Indira Gandhi. So Menaka Gandhi went to the court. She said, "Look, if this book is published, my privacy is going to be violated. My relationship with my mother-in-law, is a personal relationship. Of course, when we were friends, I have disclosed this to him. We have met around. He knows how Mrs. Indira Gandhi was. He knows how I was. Now he decides to, publish a book about this. Will it invade my privacy? Not only of mine, but my children?" So she went to the Delhi court and asked for an injunction against publication of Khushwant Singh's book. So you will notice that people are concerned that what is your personal matter is going to come into the public domain. People are concerned, right? We don't want these to go out. That's why we want to hold on to those personal secrets. Maybe we are a shy family. Maybe we don't want publicity. Of course, there are a lot of people who want publicity, and for that they create controversy. Maybe someone does not want to create that controversy. That is also possible. And that's how probably privacy comes into place in many of these cases. Okay, what's your opinion about this? What you talk, is it your privacy? Is it personal? Friends, the government has probably a habit of watching you. A lot of agencies watch you. They watch what you do, what you don't do. This is called the law on surveillance. Right? Of course, if you are under the rowdy register, this is in Karnataka, I don't know what is it called in Goa. In Goa, you may not have too many rowdies. But in Karnataka, we have this problem. So we have a special register for rowdies. The rowdies have to come every evening to the police station and put a signature, so that we know that today they have not done anything. So there is a special, but once you are in this register, please note the police has the right to do surveillance. They will follow you. They may barge into your house or your place anytime. This is part of your job. And at many occasions, a lot of political parties who were in power used to tap the telephone of a lot of MPs and MLAs whenever there was defection and so on and so forth, or what we call as horse trading. So telephone tapping becomes a very huge issue in India. And then the Supreme Court says, when can telephones be tapped and when it cannot be tapped? Right? Today, if you see any investigating agency, suppose there is a crime that occurs, Do you know how these police start solving the crime? I'm sure you've seen Crime Patrol and India Savdhan. And I'm sure in COVID, Netflix was the best place to see crime thrillers. I don't know why crime thrills us. Someone else's crime, right? It's something you must be saying, no, I can learn a lot of things from them. No, it's not. We are more interested in knowing the private life of these criminals as well. How do they think? How did they do it? So on and so forth. Friends, call record data is the first thing that the police department gets into. Suppose there is a victim, they will actually look at the last location of the mobile. Where was the last place on time where the mobile was there. So your mobile today has become a very important investigative tool. Does the police have access to how many calls you have done in a day and to whom? The answer is yes. This is called call record data. But you are lucky. They don't have access to what you have spoken in that. That is called telephone tapping. Telephone tapping means what is spoken will be recorded and will be used. So the Supreme Court did protect our privacy vis-a-vis telephones. They said telephone tapping can only be done if the police commissioner makes an order regarding the same. So local police cannot actually pass any such order on telephone tapping. There has to be a justification why it has to be tapped, and it shall be tapped only for a specific duration, and the police commissioner himself or herself will be called on to produce why the telephone was tapped. And interestingly, the Supreme Court said that politicians alone, or those who are ministers alone, cannot decide whether to tap a telephone or not. So no misuse and abuse can take place. So what you speak is something that is protected under privacy. But let me quickly compare you to digital privacy. You think WhatsApp is secure and safe? It is. A lot of people come to me and say, sir, it is encrypted. So where is WhatsApp data? First of all, no. See, telephones, your 2G, 3G, 4G and 5G, please know, they are all in India. You are happy? You are. WhatsApp, where is this? Because WhatsApp also you can make a call. You can make messages, you can send photographs, you can send videos. Right? Now please note, can the police commissioner ask for a WhatsApp call record? I don't know if you know this, very interesting. I have a few clients who just immediately send me a message and say, sir, we want a legal opinion from your side. We are in trouble, but please give me only a WhatsApp call. I was quite innocent initially. I thought maybe, general connection nahi mil raha wahan, weak hoga, signal. That's why they want a WhatsApp call. Then when the frequency of these requests started increasing, then I had to go back to the background and find out why. They were all convinced that, sir, this will not be tapped. If you make a general call, that could still be tapping because my phone is, but WhatsApp call may not be tapped simply because that call record data will not be in India. This is an assumption that a lot of people who are in violation of law have. Anyway, I don't want to demolish their good belief. Because I'm getting some business, it's okay. But the point is this. You got what I'm trying to bring about, right? The physical privacy as well as digital privacy when internet is being used. And that's critical over here, right? Okay. Do you have any objections to this? You may say Gepard is a public building. Public buildings can have CCTV cameras. Friends, interestingly, I don't know if you want to know much in detail about evidence law and criminal law. So we had a very interesting case of a lawyer who did not trust his wife. No, wives also don't trust their husband, more so very often. This was a unique case of a friend. Now, what do? You know, we have a very strange, please take me in a humorous and light manner. Most of us, we shake hands and we are okay with everything, but as soon as someone asks your phone, we are a little uncomfortable. Kya dekh lega? Our phone has so much of privacy. And husband and wives, I don't know whether they share their phones and passwords in the phones. Privacy, privacy. My phone is my privacy. We are all. So, he had no clue how to find this out. He had no idea. So what he did was he put camera in his own house. The truth came out, unfortunately. Okay? But please note, the courts have said that unless you have given consent to a recording or consent to be videographed, that cannot be used as evidence in a court because it infringes privacy. Okay, you have concluded that your wife is no longer with you. That's okay. But we cannot admit it as an evidence. Because there is a law in India called the rule on self-incrimination. You have a protection against self-incrimination. This is a constitutional protection. So friends, CCTV cameras can be there in public domain, but not in my private bedroom, not in my private house. I can put it for my own protection, but the government cannot put the same. No third party can put this camera without my consent or without my permission. And if that is done, it will not be admissible as evidence in a court of law because it infringes privacy. And that's why, friends, when these judgments came in, all public authorities were said, wherever you put a CCTV camera, please say you are under CCTV surveillance. Please inform the people that you are having someone watching over you. Right? Cameras are for that purpose. Right? Now, for example, in a lot of schools in Bangalore, we have started using CCTV camera because of incidents of violence and child sexual abuse and so on and so forth. So that is for public safety. But the parents have been informed, their consent has been sought, and larger public interest and benefit, always you can make those exemptions and protections. However, can the police or anyone else put a camera in my own house? Privacy of property and privacy of body is ultimately going to be protected as well. So I think that is again an instance of how privacy gets protected. Of course, narco analysis was another instance of privacy. Though, the court said, I hope you know what narco analysis is. This is an important tool of collecting evidence. And please note, the courts have said, even accused have privacy. And that's why when you go to a jail for a visit, you're not allowed to videograph, take cameras. Right? They also have privacy. Convicts also have privacy. Right? So in narco analysis, the court simply said, look, you can actually administer the truths only by the consent, and you cannot be forced. It cannot be injected by force because my body is my own privacy. And that's why doctors in hospitals have to take a consent before they administer an injection. Otherwise, it may amount to an offense called battery. Right? Even for your benefit, if you are not in a position to give a consent, your next of kin or your friend will be able to give that kind of a consent. So I think these are some of the traditional forms where privacy did originate. And coming to privacy under RTA Act, I think it is important to understand that the Right to Information Act also exempted privacy. Can anyone give me an example of which information was exempted under Section 81J under RTA Act? Just to capture the attention. Because after 2005, right to information became a new right. Right to privacy came only recently after the Justice Puttaswamy judgment. Right? A 9-judge bench of the Supreme Court said right to privacy is a fundamental right. Right? Any idea? Give me 1 or 2 examples of which information was excluded under RTA Act. Government, RTA. Security under section 81A, 81J. What are the exemptions? Medical information. Okay, excellent. Excellent. Okay. All kinds of medical information. Okay, fair enough. How many of you have read this section in word by word? Okay. You know, if you read section 81J, it says that personal information are exempted. Okay. But it says it can be given if there is a larger public interest. So I can justify why I want your personal information. Yes, personal information should not be given. But in exceptional cases, I can say I need it because there is a larger public interest involved in the same. I can justify that. And I'll give you how to justify it a little later. Any other personal information that is exempted under RTA? You have very less personal things, isn't it? I'm glad. It's good not to have too many personal things. Okay, friends, I'm sure you might have written some examination. Can I get a copy of your examination paper? One of you who has asked me a very tough question in this session. I want to know, can I get a copy of the same? Why not? No, you are telling me the rule. Tell me why not. It's your personal information.
Yes.
Writing an official examination is personal. So many other candidates have written. Usme kya hai? It's a paper. What's so personal about examination? What's so personal about examination? What you have written, you have got the marks. What you have got the marks, you have qualified. I don't see anything personal. Sorry, the teacher's name. Okay, you exclude that, give me your answer. I don't know if you all remember, you're all youngsters, but sir will relate it to me. Some years back, just when right to information had come into place, Dr. Seema also will know this. You know, when RTA came, there were a lot of differential judgments from information commissions. Goa Information Commission also was giving its own judgments because the understanding of law then was not very settled. So when UPSC examination question paper came out through RTA, so the question was, please state the importance of cow under the Indian Constitution. Do you know cow has a mention under the Indian Constitution? Article 48 has a mention, right? So the examiner said, please tell me the importance of cow under the Indian Constitution. The candidate who qualified that examination wrote a very beautiful answer. And that came through RTA. A cow is an animal which has 2 legs forward and 2 legs backward. And it has also a tail. And it also gives milk. Cow is a very sacred animal under Hindu law. But he wrote a very interesting answer. The description was also there. But Times of India, please note, published this answer in the very first page. They said 2 legs forward, 2 legs backward. What a description, my God. Is he an artist, scientist, or an administrator? What was he trying to tell? He said Constitution. We didn't tell him give a veterinary explanation to a cow. Friends, that case, literally, it is within your domain. So it is private. See, your own imagination of the cow is your own personal information, isn't it? How is it relevant for someone else to actually view and take it under RTA? That case actually was the case which resulted in the fact saying that let the candidate himself or herself get a copy, but we should not share this answers with others. Because it will start to get comparison, then you will send it to an expert examiner. There won't be any end to this kind of a dispute. Right? So, please note friends, the scope of RTI and trying to look at privacy was very, very disturbing at the initial stages. We did not know where to apply and what not to do. But then came the most interesting case of Shri Manmohan Singh. In 2010, the then Prime Minister Manmohan Singh, when he was in office, underwent a bypass surgery in AIIMS. This was in 2010. This was the case that actually led to determine what is privacy and what is not. So an RTI activist filed a application to the Prime Minister's office, and he said, look, I want details of what the Prime Minister is undergoing at AIIMS. What is the problem? Because, he's the Prime Minister of this nation. Is he physically and mentally fit? The nation has the right to know. So, he filed this application. He was concerned. And interestingly, in the second paragraph, he mentions that the previous Prime Minister, Mr. Vajpayee, had difficulty in standing and sitting because he had arthritis and so on and so forth. So, I'm really concerned whether there is a leader in authority. Because of course, if you are medically not fit, I'm sure in government you know that there is a line officer who will take charge. Who is the line officer for a Prime Minister? Especially if there is a nuclear button. Home Minister, Defense Minister, Cabinet, President. So he justified it. He said, look, I have larger public interest, Baba. So please tell me what has happened to Prime Minister Manmohan Singh. The PMO's office naturally said this is under section 81J, exempted, we won't give it to you. But when it came to the Delhi High Court, the court said, look, personal information is a protected information, no doubt about it. But sometimes there is government expenditure in your personal trips, life or health. So while please don't tell what happened to the Prime Minister, don't give his health status, you may have to disclose how much of expenditure was incurred in the Prime Minister's salary. Anyhow, it was AIIMS, so no expenditure was incurred. But just to rationalize, where there is a larger public interest, the court said expenses have to be disclosed, but personal details need not be disclosed. So please note, our privacy is not an absolute protected right. We have to have what is known as the doctrine of severability. Sometimes some information may have to be given, but sometimes some information will be protected information under the law as well. So that is where the test of privacy actually comes in. It's a domain that we can always include. So the most important judgment in terms of the content of what is there in privacy is about your financial information. Like Sir did say, bank. Can I know how much salary you get? Can I know what are the benefits that you get? Can I know what is there in your provident fund account? Do you want to know how much is my pension, whether it's pensionable or not? Then you may say, sir, why will anyone ask this? Friends, people are quite interested in knowing a lot of things. See, right to information is about settling your curiosities at times. Suddenly you may be very curious in someone else's life, for many reasons. That's fine. It may be government, it may be anybody else, right? Whenever in Times of India I read about CEOs' salaries, the top CEOs' salaries, I'm quite, oh yeah, I could also be one. So we are quite interested in how much wealth someone else is making, right? So is this a protected information? Is this something personal information? Friends, please note, under this new law called the Digital Personal Act, there is something called the word fiduciary that is being used. The word fiduciary means a relationship of trust and confidence. Fiduciary. Do you know which are the relationships that are fiduciary in law? Which relationships can be called as fiduciary? Doctor-patient, lawyer and a client. What does this fiduciary mean? Correct. And that trust should not be breached, misused, no conflict of interest. Apart from that. Okay. So fiduciary includes lawyer, client, doctor, patient, landlord, tenant, fiduciary. Okay, you didn't say husband and wife, trust and confidence. Okay, that's good. I'm happy for that. Friends, please note these are commercial relationships at times. And they are called fiduciary because one party is always in a position of dominance than the other party. So the person who is in a dominant position ought to act reasonably and non-arbitrarily or unfairly. That is why the term fiduciary is being used. Friends, please note, people who collect your data have a fiduciary obligation with you. That's what this law says. They have to keep this data for your interest, for your protection. But don't forget, friends, a bank also plays a fiduciary duty with its customers. When you give any information to the bank, be it a locker information, be it an FD information, be it any other information, please note, under the Banking Regulation Act, banks also play a fiduciary duty. You may be surprised, no. The Income Tax Department also has a fiduciary duty towards your tax returns. So be happy, this will not be given under RTI to anyone else. Because in the income tax returns, please note, friends, you have other sources of income as well. It could be a personal income, it could be a property income, it could be an ancestral inheritance, any other. So none of these information are supposed to be disclosed unless it is required by law. So Reserve Bank of India also is under a fiduciary obligation. Right? I hope you know that at some point of time we wanted to bring in a lot of black money into the country back. He said a lot of people have Swiss bank accounts. And a lot of these bank accounts have a lot of corruption money and tax evaded kind of a money. Okay, do you know why people used to open Swiss bank accounts? Of course, Switzerland is a good country to go. Doesn't mean the banks are necessarily good. Any idea why many Indians had Swiss bank accounts?
So no one can know like who has put the money.
Okay, that you will not know even if you go to Mauritius. Mauritius also was a tax haven country. There are so many other such nations, where you can actually go and avoid. But critically, friends, please note, the term fiduciary is relevant here. It was said that Swiss banks practiced absolute fiduciary duty. They would not disclose the bank account details to anyone, including their legal system and police system. Whereas in India, if the court makes a direction, the banks will have to disclose the same. Or if the police goes for an investigation, the banks have to disclose the same. So it's not an absolute fiduciary duty. So friends, please note, the fiduciary duty comes in this bill. That you are collecting data in a fiduciary capacity and you must protect this data as a fiduciary will do with utmost care and attention. So please note, right now, all your digital companies and your citizens are also being brought under the fiduciary ambit. That's the new thing that this law has come. So they are collecting data for your good, they'll process the data only for your good, and they will mine the data only for your good, and they will not make any commercial profit from your data. That is what is being promised under the new bill. Okay. There are so many issues about scams that did take place, where the question of whether RTI is applicable to these scams or not definitely comes into place. Okay, let's go to the issue on the judgment which brought a right to privacy as a fundamental right in India. Friends, right to privacy is now a fundamental right thanks to 9 judges of the Supreme Court that declared the same under this case called Justice K.S. Puttaswamy versus Union of India. This case actually was a case of Aadhaar. It was more a case about whether the government can collect your biometric information, your personal information through contractors, and then later on it became quite a huge case about what is privacy and who has the duty of privacy. Friends, let us try to dissect this judgment because it's very important. First and foremost, your right to privacy, can it be claimed vis-a-vis state or can it be claimed vis-a-vis non-state as well? Now, you may be saying, sir, can you explain this? I will. See, usually when we have right, who has the duty to protect our rights? See, fundamental rights. Who has the duty? It is the state. State government and central government. Right? So, if you go to Article 12, the definition of state under the Constitution, these are entities that should protect your fundamental rights. Freedom of speech and expression, movement, trade, occupation, right to life. Correct? So, right to privacy is against the state or even non-state. Now, you must be saying, sir, what are non-state actors? Facebook is non-state. Google is non-state. Indigo, Make My Trip. These are all non-state actors. Friends, to be honest, is the government collecting your personal information? Yes. Do you know who is collecting most of your personal information? The non-state. Now, Make My Trip. Interesting difference. Make My Trip, if you actually go to this app, I don't know if you use it, it can actually give you the history of all your previous trips. Where you have gone, what is the invoice, what is it? So this is an information, right? So where I travel, is it my personal information? Not with whom, huh? Where? Is it personal information where I travel? Does Make My Trip have a duty and obligation to keep this in a fiduciary capacity, protected and not divulge or disclose it? You will think, sir, why will Make My Trip give this information? To whom Make My Trip will give this? Let's assume that someone does not trust me. They go to Make My Trip and say, please give me this information and data of Sairam, but in the last 1 year, where has he traveled? In whose name has he booked the ticket? Does Make My Trip have a duty and obligation to protect my privacy? Yes, no, don't know. Was there or is there a law that makes Make My Trip responsible to keep this as personal and private information? Is there a law? Because see, I can make a request, please keep it personal. Keep it private. Suppose they don't listen, they don't like my face. Then हम दे देंगे. तो क्या होगा? Will there be any liability or Make My Trip for having breached my privacy, my personal information? Forget all that. There is a PhD student who goes to Make My Trip and says, sir, I am doing research on law professors traveling in India. I need data. How many law professors are traveling? And especially those law professors who are teaching environmental law but contributing to carbon footprint. They teach something but don't practice it. They are taking too many flights. Or, interestingly, I keep wondering, all those climate change conferences that happen, right? They all go in aeroplanes and then they say climate should be protected. Really? After so many flights? So the point is this, friends, can a researcher now take this data? You might be wondering, sir, where are you getting all these imaginative, hypothetical cases? They are not. They are real cases. I'll give you one fantastic case from South Africa. Uber. your taxi. I know Goa does not have Uber and Ola, relax. But Uber in South Africa, they had an interesting story to narrate. Please, I have to tell this story. Please take it with a pinch of salt. So, in the city of Johannesburg, they wanted to know who are taking their taxis in the evenings and from where to where, so that they can park their taxis well in advance. See, in Bangalore also, we have a lot of these IT parks. And Ola and Uber, they want to do their research about where should the maximum taxis be during peak hours. We call this surge hours or surge pricing, so that passengers will be there. So I try and have all my customers at that point there, because that office will come down, they'll take Ola and Uber, and then the business will increase, isn't it? And these IT companies don't see the fare anyways. So, but in Johannesburg, Uber comes up with this very interesting episode, and they publish this. Please note, they publish this on their website. They say from 7 to 9 in Johannesburg, 70% of people who take our taxi actually go to a red light area in Johannesburg. This comes in a newspaper in South Africa. And Uber is taken to task. Uber was asked, boss, first of all, why did you collect this data? They said, look. Better customer service. Enhancing customer experience. We justify all that. But outcome, what can we do? If everyone was going to red light area, that was not our fault. Then South Africa said, we need to bring in a law to regulate data mining. We need to tell these companies when can they mine the data, for what purpose. Because please note friends, when data is mined and it is in breach of decency and morality, then such data mining must be restricted, regulated and prohibited. Yes or no? Please note, right to privacy is a fundamental right. But the court clearly said that the restrictions under Article 19.2, what are the restrictions under Article 92? Do you know this? See, we have 6 freedoms under Article 19.1. Under 19.2, we have certain reasonable restrictions on those freedoms. Defamation is a reasonable restriction. You can't defame. Decency, morality is a reasonable restriction. Security of state is also a reasonable restriction. Right? So you cannot do some of your business and commercial activity that is in violation of decency and morality. So, lot of these companies do what we call as data processing. So, do you have right to privacy against these companies? Quickly tell me, yes, no, don't know. Friends, the judgment in Putaswamy case was a divided judgment. Some judges said right to privacy is available against state as well as non-state. Some judges said, sorry, right to privacy is only available against the state. Non-state actors, sorry, we can't say there is a right. You know why? Because most of us have agreed to compromise our privacy through consent. Now, what is consent? You have downloaded the app of Uber on your own choice. You must have read our privacy policy also. I assume you have read. And you are an adult, major, of course of sound mind, not insolvent or disqualified by law. So when you have agreed, then why shouldn't I process the data? Friends, please note, in many circumstances, we have given consent for the invasion of our privacy. We have agreed to it. It is contractual. And that's why, friends, this law makes a distinction between two kinds of processing of data. By consent and second by legitimate use. Legitimate use is of course government. Can your data be processed? The answer is yes, it can be. If you give consent for processing of that data. For example, when do I give consent to process my data? I am a subject of a clinical trial. Can my data be processed? Of course, if I give my consent, it can be processed. I agree to it. No problem. What will I say in a clinical trial? Don't disclose my name, my age, my address. But of course, what you do with me during drug trial or anything, that you can use it, you can process it. Right? Indian Institute of Science, I'm a member of the Human Ethics Committee. Every time we say, look, be very careful with processing of personal data. Rest you can utilize. Because people have given their consent, Baba. No problem. If you give consent, the processing of data is valid. Second, legitimate use. Right? Of course, investigative agency is the security of the state. Legitimate use can definitely be justified. Suppose, I am talking about mentally ill patients. Can they give their consent? No. So, under the Mental Health Care Act, if a mental asylum is trying to process data for the benefit of the mental inmates, that is a legitimate use because I am doing it for research, for advancement of medical science, for betterment of treatment of the medical patients. Then it is a legitimate use. That is definitely possible. So, in the Puttaswamy case, friends, a lot of these issues were actually deliberated. They were brought to the foresight about what is personal and what is not. I think Rohit want. Okay, sorry. Oh, I'm sorry. Thanks for saying. Okay, Rohit has just warned me that you're speaking a little too much. Maybe I'm violating your privacy of silence. Maybe what I'll do is I'll just conclude within a minute. And I will speak about the last aspect called the right to be forgotten. If some of you know about it, good. If some of you do not, then we can just take it up. Friends, under RTI Act, there is something called data retention schedules. You have to maintain your data for a certain period of time. And after a certain time, the data or the records can be destroyed or it can be taken off. Can you request some of these government agencies to remove your information, to remove your data? Is it possible? Do you have under the right to privacy the right to be forgotten? I'll give you an interesting case in Karnataka from the Karnataka High Court, which is the first case on right to be forgotten in India. Friends, a man was accused of domestic violence, physical domestic violence. And naturally that resulted in a criminal case. It resulted in divorce. And what happens is, if there is a criminal case, I hope you know this, that there is a case that runs, Sairam Bhat versus State of Karnataka. Right. This is a case record. It will remain there in the lower court. It will go to the High Court if you go in an appeal. But this information will always remain. Now today, most of these judgments are online. You can actually download most Supreme Court judgments. Hearings are also online. Interestingly, suppose I commit domestic violence, will it amount to some news? Google News, case filed, right? And if you are a famous person, driving a BMW car or anything, then the news will be more. BMW car owner, businessman, committing domestic violence, so on and so forth. So your famous personalities, even Google News makes a capture of the same. Now friends, if I honorably get acquitted in the case, please know, if I get honorably acquitted, not convicted, acquitted means free. The court says, no, this is a false case against you, you have not committed domestic violence. Can I get what is known as the right to be forgotten? You must be saying, why should this right be there? Friends, I need to remarry also. ये case तो divorce हो. Now, before remarriage, any future spouse, what will they do? You will do a basic internet search also. Now, for example, I'm sure after this class, who is this professor yaar? Came from Bangalore, boring lecture. एक बार search कर लेते, Sairam Bhat कौन है? We have a tendency, isn't it? So naturally, if someone is going to marry me next time, they will do a Google search. And first thing, if you put a Google search, domestic violence case, businessman, this will appear. Which girl will marry me? No, see, I have been acquitted. But people may think, maybe because of lack of evidence I have been acquitted. But there may be some truth, because there is no fire without a smoke. There is a perception here. Who will feel safe with a person who has been alleged with domestic violence? Will you feel safe? No. So this man went to the Karnataka High Court and said, I have been acquitted. Now this information is digitally going to be there in Google for life. My lords, you at least erase my name here. No? In the court file you erase. Court said we will erase. They said, no, that is not sufficient. Ask Google to also erase. Now Google came to those court and said, sir, I will erase in India, but it will be there in some news in somewhere. Digitally we cannot do forgotten and erase so very completely. It's not possible. Because from Google News it would have gone to Yahoo News, from Yahoo it would have gone to MSN News, from somewhere it may go to some other news. Friends, this is also privacy. This is also privacy. Right? It is important. For example, I know of a case in Goa where someone was falsely suspended in a departmental inquiry. It came as news. Of course, your newspapers have a limited circulation, but they have a digital version as well. She went to the High Court. The High Court cancelled the suspension, but the news will continue to remain. So I think it's critical that, if we appreciate how much of digital information can be abused, misused, several rights do come. And the right to be forgotten is just one such right that becomes very critical in personal privacy. Right? So I think I had some more things to say, but considering what is allotted to me, I've probably gone beyond what is being allotted to me, but that should be good. And if we should have any interaction or questions, we can probably take it up. But I've just attempted to give you the different facets and challenges that are there under this law, right from its origin to existing times, and why this act becomes important in not only regulating government activities, but regulating even non-state actors. Thank you very much.
Now the floor is open for question and answer session. Participants, those who are online live streaming, they are also requested to put their questions in the chat box, so that we will be able to read that question to the speaker and get an answer. Those who are now physically present here may put their question. Questions are private, it looks like. So we will not ask.
So,
Yeah, please.
Hello. So one question I had. Like you said, the mobile number is a private thing in the European nations. Any other things can you highlight upon or touch upon which differentiate between the West and India?
Actually, many things differentiate us from them. It is also because of, as I told you earlier, a lot of cultural practices make this distinction, to be honest. See, I'll just give you one incident. We were in Germany, and I happened to visit my brother's house there. My brother happened to be an asthmatic patient then. So that night he had severe cough. He had a bout of asthma. So he was coughing the entire night. I could hear him. I was trying and struggling to sleep. I went to check twice and thrice whether he wants something. We make this, some kashaya you can try and make with tulsi and pepper and everything. So I tried. It was not subsiding. Anyway, we both woke up early in the morning, and then, naturally I just went to the door and opened the door. There was a very interesting message from the neighbor, who also did not sleep, maybe because of the cough. We heard you coughing yesterday night. This is a good cough syrup. It's usually recommended in Germany. Please have it. Your neighbor, Mr. Stevens. They left that message, but the bottle over there, and they left. My brother did not know that he had a neighbor by name, Mr. Stevens, till then. But they were concerned. They did not infringe your privacy knocking at your door at any given point of time. They left the message over there. Of course, we met them later and thanked them. That's a cultural difference. I'm just saying, if it was India, first thing is, hey, kya re baba, kitna khas raha hai yaar? Kuch fenni pee le, something that I don't know. I'm just saying. So culturally, there are a lot of issues and a lot of challenges, right? And over there, privacy is taken very, very seriously. People don't socialize so very easily. Apart from your mobile number, your address, your car number, all of these are considered as very personal information. Marriage and family is also considered very highly personal. Unfortunately, in India, we do not categorize those information as too much of private and personal information. But there has been a growing jurisprudence in India. For example, this is a case called Hospital X versus Z. It's an HIV/AIDS patient case. It's a very interesting case. What happened in this case was the name X versus Z was precisely for this. That in India, as soon as if I disclose that I'm an AIDS patient, what will happen? First, I may lose my job. There was a lot of stigma even attached to AIDS during those days. So disclosing that, should it or can it be done? And what is your implication regarding the same? Right? So the court said being very sensitive and that kind of a health status of an individual should never be disclosed. Because people will start kind of alienating you and so on and so forth. So I think in India slowly we have started to think about privacy in a more serious context. But the reason why we cannot meet European standard is because we have already given a lot of information into the public domain. And our regulation has come quite late in the day, even for social media. It's too late. All your photographs have already been uploaded. All your events are already uploaded on some of these digital content. So, and as I told you, there are so many things that you cannot do because of simply the infrastructure that is not there in India. So we may not be able to protect everything that is there, that is attempted to be protected in the EU. However, please note, EU jurisdiction has been criticized as being too strict and stringent, taking privacy to the next level. That has been a major criticism, and that's why please know, our law in India is not like GDPR. It is not. So I hope you know that Sri Krishna, Justice Sri Krishna, was given the task of preparing the first two bills on the Digital Personal Protection Act. He drafted the bill in tune with GDPR, like the European, very stringent. But it met with a lot of resistance and challenge, saying that it is not practical in India to do it. That's why the law right now is more a principle-based approach to personal protection and not what is there in European Union. European Union law is criticized as being impractical. You can't implement such high standards of privacy and personal protection. Rather, it will defeat the purpose of so many services that the government gives you. For example, In India, suppose I am a SC student, okay? I get certain scholarship, right, from the government. Now, if you say that this is personal information, which it should be, because what I believe is my caste or my religion, which community I belong to, whether minority, majority, it's all my personal information, right? My faith, my religion should be treated as personal information. Europe it is. But in India, suppose now I treat it as too much of a personal information, then these people will be disentitled from claiming those schemes and benefits. Because they will not disclose at all. See, unless you disclose, unless it comes on public record, and tomorrow it has to be taken under RTA in some point of time, I have to know who are the list of beneficiaries. Because tomorrow it may be, I have to check whether they have submitted fake certificates or not, whether there is corruption or not. So under RTA, unfortunately, I have to take it. So in India, we have progressed a lot with these schemes for minorities, for so many other people, and that's why we don't take privacy that very rigidly like the European Union has done. So I think there are good things in India that's done already. There are good things in Europe as well that have been implemented as well. Yeah.
Thank you, sir. Thank you.
Sir, you said that no recording can be produced as evidence unless it has been consented to. But suppose if the police or any investigation agency is legitimately laying a trap to capture some habitual offender in public interest, then can it be admitted?
See, there are exceptions and exemptions for everything that has happened. As I told you, if you are under surveillance, now many of these countries, I don't know if you know this, especially after 9/11, they have a list of potential suspects who may be running a sleeper cell, or who may be inclined to a terrorist group or an organization, or who may be sympathizers, funders, sponsors. So in those circumstances, even UK, which is a very advanced country, has a surveillance law. Yeah, they do that kind of surveillance, and I think in India, we have a lot of these intelligence agencies that gather these surveillances in larger public interest. But the question is, fine if you do the surveillance, but if it is done without my consent, is it admissible as evidence in a court of law? That's the crucial question that the Supreme Court has involved. I can do surveillance, that will be a tool to find the evidence, but the surveillance itself without my consent cannot be appreciated as a evidence in a court. That's the difference. So from there, they have to collect additional evidence. They can track what I am doing, but that cannot be the basis of conviction, sole basis of conviction. Even narco-analysis, that is a tool for further investigation, but it cannot be an evidence in its own self.
So are there any mechanisms in place to destroy or delete data if I request?
There are, no doubt about it. So you can always report to any of these social media accounts. They have to develop what is known as the grievance redressal authority within their organization. And in case you find that some kind of post are infringing any of your rights, right to decency, morality, reputation, it is damaging you physically or mentally, either it is damaging you or your family, you can ask Facebook, WhatsApp or any other social media to bring down that post. You can always make a complaint and they are duty bound to adhere to the same and bring it down as well. So right now with the law, it is enforceable, but even before the law, these social media companies had implemented the same. So if you find any kind of a negative damaging post, immediately notify that kind of an agency, they'll bring it down.
And so any information which I have given previously, and if I want that information to be deleted?
You can ask them to do that, no problem. They are supposed to adhere to any such request, but again please note, they can decide. They are supposed to do it, but they can also decide saying that, look, this we cannot do because someone else wants this post to be there. That's also a possibility. So what you say, if you justify it pretty well, they will definitely bring down that post. So it will not appear in any of their mediums and places. It could be a photograph, it could be a tweet, it could be advertisement, any of these. You want to change it? First of all, if you are the one who is publishing the same, as an administrator, you can delete it on your own. But additionally, you can also request Facebook or Insta to actually bring down that as well. They are supposed to follow you, but of course they will verify whether there is authenticity through the person who has made the request, or maybe it is someone else who is doing it in an anonymous manner. So they will do all those verifications. Once they are convinced of it, they will definitely bring it down. That's also part of right to eraser. Yeah. It is also part of that.
Good evening, sir. Sir, first thing that you had told during the start of the session was that regarding apps, I'll focus more on that. Maybe Google, Instagram, or WhatsApp, or any other social media app. And these apps are used all over the world except China, which has their own apps of their own kind, which is a duplicated version or whatever their version of that particular app. So do you think that having that kind of things is better for data protection, or is it a tool for the government to do a surveillance or something like that? So if India, for example, we use Google and we use all the apps that are basically centered in US. So if we can try and come up with something of our own of these kind, will we have a better data protection thing, or is it okay to have it with them?
This is like a political question, and I don't have the political authority to answer it. But you are on a larger public policy dimension.
Yeah.
Right now, it's a little too late for us to even think about it. I think we should have done it at the very beginning of the social media, boom, or the revolution that happened. So it's too late. I think the Parliament also has realized it. The government also has realized it. So we have not insisted on that in the bill at all. In the Act, we have excluded it. Shri Krishna Committee wanted to include it, but practically we could not do it, so we have deleted it. Second, see the question about collection of data. This is inevitable now because we are all online, right? So we have to understand that this is a necessary evil, right? I don't know if you know now, there is a new app called the Digi Yatra app. So if you come to Bangalore, my face is my boarding pass. It's not biometric. Face recognition is my boarding pass. I just have to scan the boarding pass once, then till the exit of the airport, my face just go to there, show my face, couple of seconds, and then you move on. Now the Digi Yatra app is a government app. No problem. So I think it's safe to go there. But of course, once all of these step in, you will notice that there would be countries who will try and hack the cyber security system. They will try and create a data breach, as the case may be. Those possibilities, you will notice, are always, today, if you ask me, no war is going to be won on the ground. I'm sorry to say this. No war can ever be won on ground. In reality, physically, war you can't win. Digitally, this war has already commenced. So are we prepared for it? I'm no expert, I'm a law expert, but cyber security experts will have to probably answer that question. Our servers will have to be so robust, and technology has to be so upbeat. We have to be ahead of the hackers, right? So that is a challenge, and I think that is where our major infrastructure investment, if it is there, I think data can be protected in the larger interest. It is possible. But more than anything, I believe it is our responsibility on social media that is more important. I don't know whether this session is important for you or should it be important for school children. See, if you go to kids today, if you go to Insta, so much of our personal life is on Insta. Our kids love Insta. So that responsible using is important, isn't it? So I don't think we understand the implications so much. So education is critical here. We must educate how much we should be on social media and how much we should not be on social media. I'm saying messaging, texting, all that is fine. But putting your pictures, photographs, personal life on some of this, I think we have to be really careful. It's not just because the data is elsewhere. It is just because the data can be breached and misused and abused. We can immediately, do photo bombing. You can morph pictures. So many things have happened, isn't it? There are enough instances of the same. So that kind of a responsive behavior will go a long way, is what I believe in. And finally, to say in the real terms that encryption is no encryption is also very important, right? This kind of a myth has to be breached at some point of time. It is important that we understand it, be responsible, and overall we can protect our own interest in the larger sense.
So Mr. Gunachi Desai to the online platform wants to know, he has a comment for you and he also wants to know something. He says, a topic of very much importance is covered by you, sir. It created a lot of awareness on the topic. Finally, in digital world, I would be pleased to know what actually is personal confidential information.
So personal confidential information has no exhaustive list. It is an inclusive list. So everything that you consider as personal is personal, no doubt. And the SPDI rules was the first rule that defined what is personal information. As I told you, your phone number, your email, your medical information, your financial information, what else? Your biometric, all of these were considered as personal information. However, there is a differentiation even in personal information. You will be surprised to know this. Some of the personal information, we call it sensitive personal information, and then some of them we call it non-sensitive personal information. So that is also a category and distinction that is being made. However, please note, anything that is covering your body, your property, your family, any kind of transaction that you do, either health or financial, and that you consider as something that is important to you, can be categorized as personal information. Any use of social media and any messaging where you express your opinion can also be considered as personal information. So it's an inclusive definition, though the definition is there in that.
Now there is a time to wind up. On behalf of GPAR and all the participants, those who are physically here as well as joined us online, I thank Dr. Bhat for taking time to come to Goa all the way from Bangalore to enlighten us on this important piece of legislation that is brought out by the Government of India. This legislation would evolve over a period of time, because the debate has begun on this, and based on the experience and based on the response from the public, the legislation would evolve and mature in the course of time. And Dr. Bhat, thank you very much for coming here and enlightening us. Thanks a lot.